sir, are you Luther Jones?
Yes, sir.
Okay. All right, we'll go on the record in People versus Jones. This is file number 266961. The record should reflect Mr. Jones is present today by video from Otsego County Jail. Oh, where's Mr. Rolla?
Oh, I'm sorry. I went back there. I think so.
Okay. Okay, we have Mr. Rolla present. Mr. Rolla, we have Mr. Jones on the video. Mr. Trush, can you tell me the status of this file today?
Yes, Your Honor. This is our first hearing here in Circuit Court. This case is progressing a little slower than our average case, I would say. However, there are some complicating issues to it. We spent more time than usual down in district court because there was an issue of an extradition with Texas and whether or not they were actually going to come and get him or not. We still have some issues, I think, to dive into and to figure out in regards to this. I'm going to ask for a little longer an adjournment than I normally do, just because I'd like to try to get to the bottom of these before we come back here. So I would suggest to the court, I think a 60-day adjournment would probably be appropriate and would give us an opportunity to, again, get into those issues we need to get into.
Okay, Mr. Rolla.
Yes, Your Honor. In fact, my office has also been in contact with Texas and the defendant's PO in Texas. So they're aware of this situation. There was a plea offer that's on the record as to plea to counts 1 and 2 as a habitual second, for dismissal of counts 3 and 4 in habitual fourth. That offer was made by Ms. Brooker from our office, my chief assistant, back on January 28th of this year. The people have no objection to giving the defense more time. However, of course, this is not one that has anything in any other situation. We don't want it overly delayed. This is a delivery of methamphetamine case.
Okay, Mr. Jones, were you able to hear all of that?
Yes, sir.
All right. Have you talked to Mr. Trush about this 60-day delay in your case?
Yes, sir.
Do you have any objection to that?
No, sir.
Okay. All right. So, Mr. Trush, we will set this for a status conference plea hearing in 60 days. I mean, at that point, is there any reason why you wouldn't be ready to enter into a plea agreement if there is going to be one?
I would expect at that point we're likely going to be able to move the case forward, whether that's with some sort of agreement or if not, again, given the circumstances, we'd be looking to get on the trial track.
Okay. All right. Thank you. Mr. Jones, do you have any questions about how we're going to proceed with your case?
No, sir.
Okay. All right. Thank you. That concludes this hearing today, and the court's going to disconnect from the jail. Mr. Deakons, are you able to hear me okay?
Yes, sir.
All right, we're on the record in Harp versus Deakons. This is file number 2512034. The record should reflect Mr. Deakons is present by video from Crawford County Jail. This is a hearing on a show cause for a violation of a personal protection order in this case. This hearing was set for 11:45. It's now 11:52. I did check the file. The petitioner was aware of the hearing time today. The petitioner is not present. So, Mr. Deakons, in order for the court to proceed against you, the petitioner would need to be present. She's, for whatever reason, chosen not to appear today. So the court is not going to proceed with the alleged violation, and the court will dismiss the violation. However, you are still subject to all the terms and conditions of the personal protection order. You had a question?
Yes, Your Honor. Is there any way? So, I get what I'm at court today for, for the alleged violation, correct? I have my friend staying at my place in Gaylord currently, and he said that she's been driving through the parking lot, blowing the horn, throwing my property at my place, calling my work, trying to get a job where I work, trying to get me fired. And I get it's a toxic relationship, and I needed to hear this. So we try to make things work, of course, but things are just not going to work. And I want to be able to protect myself because this is all is going on because I will not pay her car payment and I will not pay her court fines. And it's just a blackmail thing going back and on. We're threatening each other back and forth, of course, and it's toxic. And I want to be able to protect myself as well. How do I do that? Is my question.
So that would require me to give you legal advice, and I might have to preside over that case at some point, so I can't tell you what to do or what not to do.
Yes, sir.
I would just advise if you believe that your property is being damaged or destroyed to notify law enforcement.
Yes, sir.
Do you have any questions about the proceeding today?
No, sir.
Okay. So the court won't proceed any further on the alleged violation that's offered this hearing today, and the court's going to disconnect.
Is there any way to, what do I got to file to get it rescinded, or what's that word I'm looking for? Rescinded, like to, I'm not sure if, I apologize. I just don't know what I'm talking about.
Sure. Again, that would require me to give you legal advice about what to do
Yes,
or
sir.
what not to do, and that's not my role, and it wouldn't be ethical for me to do that, so I can't tell you what to do.
Yes, sir. All right. I have no more questions, and I thank you for your time.
All right, thank you.
Yes, sir.
All right, sir, are you Kyle Robbins?
Yes.
All right. Again, we're on the record in People versus Robbins. The record should reflect Mr. Robbins is now present from Roscommon County Jail by video. Mr. Dick, can you tell me the status of this file here today?
Yes, Your Honor. So I received notice that the prosecutor's office was sending out the remaining piece of discovery by mail. Yesterday, pardon me. So I would ask for an adjournment so that I can go over this discovery, the video discovery, and the photograph discovery with Mr. Robbins before deciding how to proceed.
Mr. Rowland?
No objection.
All right, given the nature of the charges in this case, I think it's a reasonable request by defense counsel. Mr. Dick, how much of an adjournment do you want in order to be able to do that?
I would ask for 30 days, Your Honor.
Mr. Robbins, were you able to hear all of that?
Yes.
All right, do you have any questions about how we're going to proceed with your case?
No.
Are you under sentence there in Roscommon, or do you know how long you're going to be lodged there?
I don't have any idea yet. I'm not sentenced.
Okay, do you know Mr. Dick?
So I believe he's awaiting sentencing on a probation violation. So, and he's being held on this matter and one other matter as well.
Okay.
So,
all right, so we'll set this for a hearing by Zoom. Mr. Roll, I'll just request that you prepare a writ for Mr. Robbins' appearance from Roscommon.
He believes he'll be in the Roscommon County Jail still for that time. Fine, Judge, I'll take care of it. Make notes in the file. Thank you.
Okay. All right, thank you. That's all for today. Will you be in touch with Mr. Robbins?
yes.
Mr. Robbins, your attorney will be in touch with you prior to that next hearing, and we're going to disconnect at this time.
Thank you.
Okay.
That concludes. We need Cornett brought up and Jones. Yeah. Mr. Valdori, are you able to hear me okay?
I am. Thank you so much. Yeah.
Okay, we're on the record now in People versus Millsap. This is file number 256912. We have Mr. Rolla present here in the courtroom today. We have Mr. Millsap present by video from Department of Corrections and his attorney, Mr. Baldori, by Zoom. This is set as a status conference here today. Mr. Baldori, I know this is your first appearance on Mr. Millsap's behalf. We did have a jury trial scheduled for March in this matter. The last hearing Mr. Millsap was in the process, I believe, of retaining you. And so we had indicated for the record that we were going to adjourn that trial, just prospectively looking and suspecting that new counsel was going to want more time to be able to get up to speed in the case. So with that background, Mr. Baldori, can you tell me where you are at right now with this matter? And then we'll conduct some further scheduling here today.
Thank you. That is accurate, Your Honor. And if given the opportunity, I might like to speak with Mr. Millsap in a breakout room. But first, I'll address the court that yes, I did send in my appearance and request to the prosecutor's office. I think yesterday or the day before yesterday. I have some of the documentation discovery, but I don't have like the video discovery and so on. I can communicate with the prosecutor's office further in relation to that. I just want to make sure I have everything. And then, yes, yeah, just having some time to get through this, understand the parameters of this case, and then, yes, proceed to, having trial dates set. Not quite sure what I would request in terms of the timeline quite yet until I kind of get into the discovery a little bit more, but I can certainly leave it to the court to set those dates and just provide sufficient time for us to get a handle on the case.
All right, thank you. Mr. Rolla, I mean, I know you were probably gearing up for the trial, at least prior to the last hearing, but do you need an extensive period of time to be ready to go?
I do not, Judge. Again, if people have no objection to an adjournment in order to avoid a number of conflicts that would otherwise perhaps create appealable issues, 60 days if the court wants to do that might be appropriate. I'd also advise defense counsel, yes, our office did receive your appearance, so discovery materials are being sent out. As to the other videos and stuff, you'll probably receive also a response letter from our office indicating how you can obtain those copies, either from prior counsel or available directly from our office. And I would additionally indicate that there was added plea offer that you would not have been aware of, perhaps that was extended back on in September of last year prior to trial, of an added count of criminal sexual conduct, first degree, multiple variables that would have, of course, taken away the 25-year mandatory minimum with the charges that are currently pending.
Okay,
understood.
So Mr. Baldori, I would like to get this on the trial calendar. I have no problem, building in enough time for you to be prepared. But if the court were to set this, 4 to 5 months out, is that going to be enough time, or is that too much time?
I would appreciate that. Yeah, I'm pretty solid booked through certainly the rest of this month and a lot of April. But yeah, that's good. That gives me time to negotiate my schedule. And I will. So when prior counsel is referred to, I'm not quite sure. Mr. Millsap had been corresponding with Michael Mataloni's office. He has sadly passed away. I took over a certain number of his cases. I don't know what discovery. I'm not sure if what he had was comprehensive in regards to the discovery as to this case. So I do want to work with the prosecutor's office to make sure I have everything. And if I have to go out of my way to get some of these materials, I'm happy to do that. So that's just something we have to get to.
Okay.
And Judge, I would suggest a final status conference at least a month prior to trial. So that way defense counsel can confirm that they received all the discovery that they need in order to prepare for the trial.
Agreed.
Okay, so the court is going to set this about 4 months out for a 3-day jury trial. Mr. Baldori, it's typically my practice to set it for a final status conference about 30 days prior to the trial date. That status conference is the plea cutoff. So to the extent that Mr. Millsap wishes to further consider any plea offers, that final status conference would be the last date to enter into any pleas. Either side is free to file motions at any time, but the motion cutoff is also that final status conference. So any motions need to be filed and heard no later than that date. And Mr. Baldori, I'll send out a scheduling order that reflects those, as well as instructions on trial preparation. So you'll get a copy of that with the dates that we've discussed here today.
Okay.
And then that's how we'll proceed. Mr. Baldori, anything else that I can address for your side here today?
I have nothing further on. I appreciate it.
Mr. Rolla?
Just for the benefit of the defense counsel, if there should be some issue regarding discovery material, just contact our office manager, and we'll make sure that that's provided.
Thank you. And if the court, I'm not sure if the court can accommodate me on this. Is it possible for me to go into a breakout room with my client?
Yes, I can absolutely do that.
Okay.
Mr. Millsap, before we do that, do you have any questions about how we're going to proceed with your case?
I do not.
Okay. All right, I'm going to open that breakout room right now then.
Thank you, Your Honor.
All right, and then that will conclude that hearing, Mr. Baldori. Once you're done, and feel free to use as much time as you want, just go ahead and disconnect. Present here in the courtroom today, if I could have counsel put your appearances on.
For your record, Mike Roll, on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Mr. Lundy.
All right, and Mr. Trush, this is set for a probation violation hearing today. How did you want to proceed?
Your Honor, I've been in communications with Mr. DeLeo, and I think we have a resolution of this. Mr. Lundy would be tendering a no contest plea to counts 1, 2, and 4. Counts 3 and 5 would be dismissed. Mr. DeLeo is recommending credit for the 122 days in jail, credit for the 122 days he's already served, and dismissal from probation. The reason for the no contest plea is Mr. Lundy has a trial on the Antrim County allegations, which form the basis for the violation. He indicates to me set in about 2 weeks. We don't want the admissions here to potentially jeopardize that trial.
Okay, and what are we going to use as a factual basis?
I think the court could rely on the affidavit attached to the probation violation.
Okay. All right, Ms. Davis or Mr. Rowland?
Judge, I understand the defense position as to some of the allegations, but I don't understand why if it's a no contest plea, that would have anything to do with being gone or not a listed address. How does that impact any other pending charges?
Yeah, I mean, I would agree with that. Other than for procedural purposes, it might be easier to take a no contest plea to all of them instead of a guilty plea to 1 or 2 and no contest to others.
I just want to say that to clarify the record, John. Thank you.
Ms. Davis, anything that you want to add?
And he's asking that fines and costs be preserved as well.
Okay, did we want to move to sentencing on this today?
I think it would be appropriate given what the recommendation is.
Okay. I'm just looking for that affidavit here.
I have a copy of it.
Oh, good. Can you bring that word?
And it has the paragraphs marked.
Okay, Mr. Lundy, excuse me, have you had a chance to talk about this agreement? And so what is the sentence agreement in this case? Or what is the recommendation?
Agent DeLeo was asking that on probation be revoked unsuccessfully, preserve fines and costs, 122 days jail with credit for 122 days served.
Okay. All right. So, Mr. Lundy, have you had a chance to talk to Mr. Trush about this agreement?
Yes, Your Honor.
Is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Lundy, you understand that you do have the right to have a hearing as to whether or not you violated your probation,
Yes, sir.
and that by pleading no contest here, you're going to be giving up that right.
Yes, Your Honor.
Also, although we have an agreement, I think, as to what the sentence is going to be, and I don't think I'm going going to depart from that, but by pleading no contest, it could subject you to the maximum penalty on your underlying charge, which is up to 2 years. Do you understand that?
Yes, Your Honor.
With that in mind, what is your plea to the alleged probation violations?
No contest.
Has anybody threatened you with anything to get you to enter this plea today?
No, Your Honor.
Has anybody promised you anything other than what we've said here on the record?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Okay. I do want to confirm just a couple things. Back on August 16th and September 8th of 2025, you were on probation here in Otsego County. Is that correct?
Yes, Your Honor.
Okay. All right. And Mr. Trush, you've reviewed the affidavit in support of the alleged violations.
I have.
Do you agree that if true, those would provide a factual basis for finding that Mr. Lundy did violate his probation?
Yes.
And Mr. Rolla, have you done the same?
I haven't seen the affidavit at all. None's been provided to my office.
Okay, can you take a look at that?
Yeah. Okay, I have something that's marked as a probation request violation, if that's what's being referred to.
Yes.
Okay. Is this what you're talking about?
Yes.
In that case, Judge, I have reviewed it and I have no objection. I do believe that it meets.
Based on that, the court finds that there is a factual basis to support a finding that you did violate your probation as alleged. The court will accept your no contest plea. Other than what has already been stated, Ms. Davis or Mr. Rolla, anything regarding sentencing in this case?
No, thank you.
Mr. Trush.
Your Honor, I would just indicate, I think that the recommendation is appropriate in this situation. I think when all is said and done on this matter, Mr. Lundy has spent about 11 months in the county jail between the sentence on the initial charge. I think we had one prior violation to this, which again, he served additional time on. And then he spent, I think, about 4 months in Antrim's jail when the new charges came and the violation warrant came down. So again, all said and done, he's served a significant amount of time on this. At this point, it makes sense to terminate the probation, I think, and the recommendation is appropriate. We ask court to follow it.
Mr. Lundy, anything you wanted to say today?
No, Your Honor.
All right, I did review the file prior to the hearing today, so I'm familiar with the original charges in this case and what's gone on during the time you've been on probation. Based on that, I agree with Mr. DeLeo's assessment that there's no benefit to be gained by continuing you on probation here. I also agree with the recommendation in terms of jail time. I find it's appropriate, and I don't have any reason to depart from what Mr. DeLeo finds is appropriate, given his monitoring you and his knowledge of your situation. So the court is going to adopt the recommendation. The court will sentence you to 122 days in Otsego County Jail with credit for 122 days served. The court will preserve any outstanding fines and costs and discharge you unsuccessfully from your probation. You do have the ability to seek an appeal of this sentence, and Mr. you can have Mr. Lundy acknowledge receipt of this.
It's just to acknowledge that you received it in today's report. 3-4.
Sorry, the record should reflect Mr. Lundy's acknowledged receipt of his appellate rights. That's all for today, Mr. Lundy. You're free to go. And Mr. Trush, if you can just let us know when you're ready on Mr. Fick's case.
Understood. I have not seen him check.
Sure. I mean, we're early, but we can take that at any time you're ready. People versus Fick. This is file number 256938. The record should reflect that Mr. Fick's present in the courtroom today. If I could put your appearances on.
The record, Your Honor, my fellow behalf of the people.
Your Honor, Richard Trush on behalf of Mr. Fick.
Mr. Fick, were you aware that your hearing was at 9:30 this morning?
That's right.
Is there any reason why you weren't here at 9:30?
They ran late traffic. I had to come from downstate this morning, first thing this morning.
It's perfect weather out there.
I know.
Couldn't have been due to the snow. You understand that you're here for sentencing, right?
Sure.
And I assume you're going to be asking the court to, go easy on you. And when you show up late for your hearing, it's not a good start to that. You understand that? And I got a letter from your employer who indicates that you're a great employee. Do you show up late for work? No. Have you had a chance to go through the pre-sentence report with Mr. Trush and talk to him about that? What's that?
I have not.
Okay, why haven't you done that? Mr. Trush.
You know, I guess can we have a minute to go over the report?
Did you?
I understand what's on there, so we can proceed.
No, I have to give you a chance from a legal standpoint to go through it with him. Did you not call him, check in with him, anything?
We talked, a couple days ago?
Okay.
Or you talked, we communicated, but we didn't go over really. We didn't go over that.
Okay. All right. We'll take about 10 minutes, Mr. Trush, and go through that with Mr. Fick. Mr. Fick, did you have a chance to go through that report with Mr. Trush?
Sure.
All right, Mr. Trush, are there any additions, deletions, or corrections to the report?
There's not, I do just want to make a clear record on that. Mr. Fick and I talked when the report came in. We talked again a few days ago. I don't remember if it was Monday or Friday of last week, but a couple days ago, we went through it again. I think the hearing kind of got off to a rocky start, and I think Mr. Fick was a little bit nervous when you asked him that question.
Okay.
But we had gone over the recommendations and what's contained in the report. We don't have any corrections, additions, or deletions.
Okay, good. Thank you for that clarification. Are there any challenges to the scoring of the guidelines?
No, Your Honor.
All right. And as I indicated, I did receive the letter from Mr. Matera from Vesta Homes. I did have a chance to read that prior to the hearing today. Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Do the people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Briefly, Judge, this is a possession of methamphetamine as well as analogs, alpazole, if I remember that correctly. Third and fourth felonies, perhaps of maybe even greater concern, 6 and 7 controlled substance convictions as indicated in the adult record under numbers 1, 5, 6, 10, and 12. There is a recommendation of jail with 8 days credit. I think in light of the fact that this is a now 8th and 9th controlled substance, I think jail would be appropriate. I have no other comments for the court. Thank you, Your Honor.
Thank you, Mr. Trush.
Your Honor, I think the prosecutor's read on this is actually fairly accurate. As I went through the history, there's 13 entries in his criminal history section. 9 of the 13 entries, I think, would squarely fall in what I would consider substance offenses. So either possession of a substance or something directly tied to use of it, so like an OWI type offense. The remaining 4 offenses are what I would call substance adjacent, and they are the type of offenses that I think we typically see where when we start to kind of trace back the series of events, it often starts with somebody consuming a substance, and then things start to get out of hand from there. And I think that if we look at Mr. Fick's history, it paints a very clear picture. I think the letter that was sent by his employer shows that he's a good employee. And I think he is a good and reliable employee when he is sober and in his clear mind. And I think that his criminal history paints a very clear picture of someone who struggles with substances. Even if we look at the offense here, I mean, what we have is an offense that is very small amounts. The methamphetamine amount is residue. And there's 2 pills of So there's a prazolone, 2 pills. I think that paints a clear picture of, again, usage, not anything more nefarious than that. And looking back at his history, again, I don't see anything here that suggests anything more than someone who has a use problem. Which is to say, there's nothing in his history that suggests that he's selling or delivering or, again, anything more nefarious than he's been caught using. I agree with the prosecutor. I think his history is getting to the point where we're kind of at the last stop here. I suspect that this is likely a county jail sentence. That's what the recommendation calls for, and that kind of feels like the right place for this. It would seem to me, if he's back in front of the court again, this court or a different court, it's probably looking at MDOC sanctions. Based on where his guidelines are now, that could happen today. Again, it doesn't seem the most likely scenario, but it could. I would suggest to the court that I think a blended sentence is appropriate. I suspect the court is looking at doing some upfront jail. Obviously, that's what the recommendation is. I think for Mr. Fick, he would strongly benefit from some treatment. I would suggest to the court a reasonable sentence, maybe to impose some jail, but give him an option to engage in treatment and potentially reduce that jail sentence by doing so. I think that would provide him a strong motivator to engage in the treatment. And frankly, I think that time is better spent in treatment in the jail. I think it's better for him. It's better for the community. When sober, he is a productive member of the community. So I would ask court to consider that. Thank you.
Thank you. Mr. Fick, anything you wanted to say today? I did read through the report, so I'm familiar with what happened in this case. You were before me, not too long ago on a very similar case. And in fact, your 2 arrests were almost exactly a year apart, June 25th, 2024 and June 28th of 2025. And both very similar circumstances. I agree with Mr. Trush. There doesn't appear to be any more substantial involvement with substances other than use. They've been small amounts. I mean, the circumstances were almost identical, other than one time you were riding a motorcycle and the other time you were operating a vehicle. Same officer, in fact, that conducted the stop. So very similar, very indicative, I think, as Mr. Trush indicated, of use type offenses. I did read through the letter from your employer. Based on that, it does appear that you're a good employee. I would have no reason to disbelieve what your employer would have to say about you. And so this is kind of that circumstance where at some point you're going to need to get help and stop using, because it looks like you have the potential of moving forward and making a living and working and doing all the things that regular, normal, productive members of society do. And this is getting in the way of that. And it has been for some time, obviously, based on your record. And I did review the prior sentencing hearing that we had before. I think I highlighted a lot of the same things again. And based on your prior, probation sentences, you've been on probation 6 prior times. It continues to be my view that further probation isn't going to be productive. It hasn't worked up till now. I don't think it's going to work. I think to the extent that you want to seek treatment, that's something that you're going to need to do on your own, because you want to stop ending up here in front of me in this courtroom getting yelled at for showing up late. And I hope that you get to that point. And if you don't, Mr. Trush is absolutely correct. I mean, the upper end of the guidelines here is 20 months in prison. And I don't think at your age and your station in life, you want to start going to prison. So that is going to be an absolutely detrimental thing for you and for any hope of recovery. So this really is your last chance to avoid that, because I think the next time your guidelines will be within a prison sanction. And whether it's me or a different judge won't have the option of probation or jail. That being said, your previous sentence was 6 months. I think, of course, the court is going to sentence you to a higher sentence than that this time. I think a local jail sentence is warranted. I don't think prison is warranted based on the nature of the offense here. There isn't any aggravating factors here that I think would warrant a prison sentence at this point. But certainly, as you continue to offend, penalties get higher. And so the court is going to sentence you to 9 months of jail, straight jail in the Otsego County Jail. You have credit for 8 days served. That's, in the lower third of the guidelines. I think it adequately accounts for your past history as well as the offense in this case and the mitigating factors. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $136 state costs. That says to both counts to be served concurrent to each other. You do have, and I don't know what your status is now or where you're living, but I don't have an objection to immediate release to work camp. This is a nonviolent crime. I don't find that you present any kind of danger to public safety. And I think given the nature of this offense, there's no reason why work camp shouldn't be an option if you're otherwise eligible. So the court has no objection to doing all of that time as part of the work camp program. You do have the ability to seek an appeal of this sentence. Mr. Trush, can you have Mr. Fick acknowledge receipt of this appellate rights, please?
And Judge, did you want to, okay.
That's not my list.
Okay,
That's just, thank you.
yeah.
March 4th, yeah, March 4th.
And then Mr. Rolla, there was, and Mr. Trush, this is a matter of record. There was some confusion about the plea agreement here. The amended information doesn't help clear that up. That's it.
I didn't look at that. Okay, yeah, if we can use that, if you want to.
So that would be counts 1 and 2, amended information.
Yes,
Okay.
yeah,
And you said the note indicates there was a F4.
Was a half.
Yes.
But it was amended down to a half.
Okay.
yeah.
So if we're good if we change it. There was a difference in what the original information indicated in the plea agreement. We needed to resolve that discrepancy.
Yeah,
Correct, the court should have already received an amended information indicating that instead of 769.12, it's 769.10.
and then, yeah, they said count 3 was dismissed. There was not a count 3 originally.
Okay.
It looked like it was the enhancement, the second offense notice
Okay.
that was needing to be dismissed.
Okay.
instead.
So are we good
Yeah,
now?
I think, yep,
Okay.
with that amended information. Thank you.
Okay. Thank you, Mr. Fick. We're going to go with the officer this time. Mr. Trush, I have Mr. Albert connecting.